Welcome, Constitution Television, Constitution TV here on YouTube. My name is Douglas V. Gibbs, your host, douglasvgibbs.com, politicalpistachio.com, and you can send me questions at douglasvgibbs@yahoo.com or constitutionspeaker@yahoo.com. I'd like to welcome you to this particular episode. This one is a question asked by Ron. And here's the question. I want to read it word for word so we get the full gist of the question here. Not sure if you know how the Obama administration spied on Trump and potentially engaged in a coup to remove him. Obviously, a guilty verdict will have to be rendered to make my question valid. My question is, if Obama is found to have been treasonous, what are the repercussions? I have heard if a president is found guilty of treason while he was president, any actions he took, court appointments at any federal level up to and including Supreme Court, legislation signed and executive orders signed become null and void. If this is the case, are all actions he took reversed? Does it go by the date in which the offense was committed? There are a lot of people out there who want to know. If you do a video about this, I will share the heck out of it. All right, well, let's talk about this. And there's many layers to the question, so this video may wind up a little longer than the more recent ones, but we'll go through this as best as we can. And also, when it comes to a question about if a president is prosecuted for treason. In the case of Obama, we're looking at a former president, if a former president is prosecuted for treason. But I'm also going to enter into this if a current president is prosecuted for treason. We'll answer both questions because we have a lot of liberal friends out there that would love to see President Trump impeached for treason. They think he's guilty of treason. And conservatives believe that Obama was guilty of treason. And we're going to go through the definition of treason and the repercussions and all of that in this video. So, okay. So first of all, let's pull out the Constitution. And I've marked my constitutions in some places so we can find it quickly. So I basically found all the places that discuss impeachment and treason. I'm going to discuss each of them independently, and then hopefully at the end they'll all come together into a picture that we can properly understand. So the first time that impeachment appears in the Constitution is in Article 1, Section 2. Now remember, Article 1 of the Constitution is regarding the legislative branch. Article 2 is regarding the executive branch. Article 3 is regarding the judicial branch. So let's recall that. And it is the very last sentence of Article 1, Section 2, and it reads as such. The House of Representatives shall choose their Speaker and other officers and shall have the sole power of impeachment. Sole power of impeachment. What is impeachment? Impeachment is not removal from office. Impeachment is the indictment, the charge. So, only the House can charge, and then it goes to the Senate for the hearing, which I'll talk about in a minute. Now, this is significant because of the way the Congress was originally set up. Originally, Congress had our bicameral Congress, our two-house Congress, had two unique, different from each other branches. Houses of Congress. So, in other words, they were like a mother and a father, in a marriage, where you have two totally different and distinct different parts of the body. The Senate, the senators, were appointed by the state legislatures. So the senators' main interest was what was best for their state. The members of the House, as they are today, were voted in by the people, democratically. So therefore, the House of Representatives was the voice of the people. The U.S. Senate was the voice of the states. So by reading this, what it's saying is only the people have the power of impeachment. Only the people can levy charges, okay, against our critters in the federal government. All right, so that's the first part. Now, here's the second part, and this is when we talk about the Senate a little bit. In Article 1, Section 3, it says, the Senate shall have the sole power to try all impeachments. Okay, so the people's house charge, but the house that belongs to states, and these were expected to be politicians with that were more savvy politically and more experience. Now, if you look at the requirements, minimum requirements for House versus for the Senate, for the House it's 25 years of age, for the Senate it's 30, so on and so forth. So these are supposed to be wiser, more politically savvy members of Congress that are in the Senate. And they're the ones that do the trial. In other words, it's okay, people, you want to charge this guy? Let's find out. All right, when sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside. Now realize that normally the President of the Senate is the Vice President of the United States. But what this is saying is if the Senate has gotten together for an impeachment, a trial for impeachment, a hearing, the Vice President steps aside and the Chief Justice comes in to preside. So the Chief Justice is the one with the gavel. The Chief Justice is the one who's basically being the judge over the case, and the members of the Senate are the jury, essentially. And, well, the jury and the lawyers and everything else that goes along with it. And no person shall be convicted without the concurrence of 2/3 of the members present. Okay, so in the case of impeachment, the House only needs to impeach with a simple majority. But when it comes to the Senate, it requires a 2/3 of members present, and there must be a quorum, so at least half plus one, in other words, a majority, needs to be there, present. And then out of those present, 2/3 are required for the impeachment to go into play. Convicted. Okay. Judgment in cases of impeachment shall not extend further than removal from office. What that's saying is the criminal part of impeachment, the criminal part doesn't happen here. This is just to decide what the punishment is, all the way up to removal from office is going to be. Then it says, and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. So removal from office could mean Pete Rose was banned from baseball. You get banned from government. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. In other words, if there is going to be a criminal case, there can be, but it's after they're removed from office. So the impeachment is only for deciding whether or not they're going to be removed from office. So now in the case of President Obama, he's gone. So there is no impeachment. There would only be a trial afterwards, a civilian trial, but that still can play. That still can happen. In the case of President Trump, while he's holding office, let's say hypothetically that they pulled off an impeachment, that'd be the removal. Then once he's out of office, then there will still be the steps of going through the process of the criminal trial, charging, and grand jury, all that jazz. Grand jury doesn't happen while they're in office, per se, because the impeachment is all about the House charging and the Senate hearing, and then whether or not they're removed, and that's it. So even if, like back when Obama was president, if he had gotten in trouble for impeachment, they couldn't have charged him and jailed him while he was still in office. he would have needed to first go through the impeachment process, be removed from office. Then once removed from office, then the criminal part comes in. And then criminal charges are given, and process starts all over again, so to speak. All right. Next part. This is in Article 2, Section 2, and it says, he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. What that's saying, remember Article 2 is the president. What that's saying is the president may pardon anybody for anything except in cases of impeachment. That's why it was significant that Nixon resigned before he was impeached. Ford was able to pardon him because he had not actually been impeached. In other words, charged by the House. Had impeachment gone through, there would have been no pardon. There couldn't have been. Okay? So, now, next part here. Article 2, Section 4 of the U.S. Constitution. And this one actually creates a lot of confusion. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for the conviction of treason, bribery, or other high crimes and misdemeanors. In other words, conviction by the Senate. If there's an impeachment for any other reason, then they could be censured or whatever. But here, what it's saying is, the President, the Vice President, and the civil officers of the United States, if they're convicted of treason, bribery, or other high crimes and misdemeanors, which pretty much means any crime, because high crimes is not, a lot of people believe that high crimes is, it's a big crime, like a felony. No, high crimes are crimes committed by someone holding high office. And so the President, Vice President, and all civil officers of the United States shall be removed from office. Some people believe that if the President is removed from high office for those reasons, that means the Vice President and the civil officers also have to go. That's not what it's saying. It's saying if the President or the Vice President or the civil officers of the United States are guilty and convicted as such by the Senate during an impeachment trial of treason, bribery, or other high crimes and misdemeanors, the punishment has to be removal from office. It can't be censure or something like that. All right, now we're going to get into the nitty-gritty. Now we're going to start getting into where we're answering Ron's question more directly. This is in Article 3, Section 2. The trial of all crimes, except in cases of impeachment, shall be by jury. All right, so if it's not by jury, that means it's an impeachment. If it's not an impeachment, it's by jury. If it's impeachment, it's by Senate. Okay? Article 3, Section 3. This is the definition of treason. Treason against the United States shall consist only, the word only is very important there. That means this is it. Nothing more than this. In levying war against them, against the states, them being the states, or in adhering to their enemies, giving them aid and comfort. All right, so now this is important. What this means is that disloyalty, bad policy that harms the United States, those are not reasons for treason. Those are not treason. Sloppy handling of classified material, it's not treason. Is some of what Obama did while in office, was it technically treason? I think some of the things can be considered that. But a lot of things people think was treason is not treason. Once again, let me read it again. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. The bad deal with Iran was not treason. Now, arming an enemy that's being used to levy war against the states. Let's say the Fast and Furious scandal. It depends on if those guns got in the hands of who are considered enemies. I would say if Middle Eastern terrorists were getting their hands on those firearms, and I believe they were, then that would be treason, because it was aiding in them levying war against the states, because they come into the United States, they're using the firearms to levy their jihad or holy war against the states. So I guess that could be considered treason. Really bad policy is not treason. Okay. And it's interesting, too, because when it comes to treason, what was it? Kramer versus the U.S. in 1945 really kind of changed how cases about treason are put in play. What it did is it allowed for non-treason charges without the procedural safeguards of treason to be charged. In other words, things that would be normally considered treason, but they're like right on the fence there, they could be considered non-treason charges. What that would do when I say remove the safeguards, in other words, it wouldn't take two witnesses. And I'll get into that in a minute. So by Kramer versus U.S., look it up, 1945, really kind of started that process where they kind of dance around treason with non-treason charges. And by 1954, those types of cases were appearing so much that you really didn't see cases on treason anymore. So because of 1945's Kramer versus U.S., treason has been a difficult criminal case to pursue. If that makes sense. All right, so let's continue in Section 3 here. So treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses, which I mentioned just a moment ago, to the same overt act or on confession in open court. The Congress shall have power to declare the punishment of treason. Let me now correct a lot of folks out there on this one. I can't count how many people have said, oh, well, the penalty for treason is death. It says so in the Constitution. No, it doesn't. What it says in the Constitution is Congress has the power to declare the punishment of treason, and they have declared that the punishment for treason is death. Now, that said, not every person convicted of treason has been put to death. There have been cases where, throughout history, and matter of fact, think of a couple cases in 1850, I think it was, where one resulted in death and the other one did not. But not every person found guilty of treason has been executed, historically. But for the most part, Congress has declared the punishment of treason to be death. But it does not say in the Constitution that the punishment for treason is death. So if you hear anybody say that, hey, it says right there in the Constitution, if you commit treason, you got to be executed. That's not what it says. It doesn't say that. Okay. Then it goes on, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. So corruption of blood, in other words, the rest of the family isn't guilty. You're guilty for treason, but that doesn't automatically make your whole family guilty. That's what corruption of blood, that's what that is. Or forfeiture except during the life of the person attainted. Once that person, let's say you're guilty of treason and you're executed, forfeiture of goods or whatever is no longer necessary. It goes, once again, that protects the family. All right, now let's get back to the full answer, another part of the answer here. So now, let's say Obama or Trump, either one, depending on which side of the fence you ride, is found guilty of treason, convicted, and put to death. Does the laws that they signed during their presidency remain in effect? There's a belief that if Obama or Trump are found guilty of treason, then anything they signed is null and void, because then it was as if they were not president. And Ron, I'm sorry to say, that's not the case. Only the legislature has the power to reverse law. So a smart legislature, let's say President Obama was found guilty of treason, convicted, put to death. A smart Congress would then revisit those laws that he had signed and reconsider them. But at the time, they were signed into law by what we believe to be legitimate practice. You know, and all countries kind of operate in this manner, as a matter of fact. I'll give you an example. Germany has a law in the books that doesn't allow homeschooling. It's very restrictive when it comes to schooling. You can only be educated by the state. That law went on the books during the Nazi regime. When Hitler was finally defeated, all of the laws that he put in place were not just suddenly gone. Whether or not he was a tyrant, or whatever you want to call him, the fact is the legislation that had gone into place had gone into place. And so it was treated as standing legislation. Same thing with if we have a president who's impeached, or let's say, go back to even the natural born citizen thing. Let's say while Obama was president, they had discovered he was not eligible after all, and he was removed from office due to lack of eligibility. The fact is, when he signed the laws, we believed him to be legitimate, and therefore those laws would still stand, and the only way to remove them is for the legislature to do so. And a smart legislature would. But it does not automatically make null and void any legislature he had signed, or at least not constitutionally. Now, I perused the best I could the United States Code, and I didn't see anything in the U.S. Code either regarding that. So I don't believe that there's any federal law that would make null and void any laws signed by a president convicted of treason or removed from office for whatever reason, eligibility or whatnot. And there's nothing in the Constitution that says that anything they signed is null and void. So that part of your question, sorry to say, didn't turn out the way you thought it might. But it is a good question because it's been asked a lot. I remember when Obama was in office, I was asked that question a lot regarding the status on natural born citizen. You know, what if he's found to be not eligible? Does all of the things that he signed become null and void? And his appointments become null and void? No. Unfortunately not. There's nothing in there saying that. Nothing that I've seen anyway. If I'm wrong, please show me the U.S. Code section, article, chapter and all that, and I'll take a look at it. But I could not find anything in the U.S. Code, and in the Constitution there's nothing that says that. All right, hopefully that answers all the questions. I appreciate the question. And it's funny because sometimes people do have a misinterpretation of the Constitution. For example, going back to that, the death penalty for all cases of treason is in the Constitution, and it's not. And that's part of the reason I do what I do, because I want to make sure that we do have it down straight. Now, that said, treason is a very serious crime. And in the case of Obama, eligibility was a very big deal. In fact, to be honest, he wasn't eligible. Not because of any birth certificate in Hawaii or anything. That really didn't matter. If you go back to, not that this is a video about natural born citizen, but I want to say it real quick while it's on my mind. If you go back to Vattel's Law of Nations, the Immigration and Naturalization Act of 1790, and now we can get into a discussion about how 1795 influenced the 1790 Immigration Act, and the Happersett versus Minor versus Happersett 1875 case. In all three cases, natural born citizen is defined as a person born of two citizen parents. So Obama could have been born on the front steps of the White House, and by his own admission, he was not eligible because his father wasn't a citizen at the time of his birth. So we did have a president that was not eligible serve an entire 8 years. And nobody cares, or well, some people care, but all that legislation is going to stay in place, even if somebody later declares, oh, he wasn't eligible after all, and everybody agrees. Fact is, all that legislation is still going to stay in place. The only way to repeal it is for the legislature, Congress, to start that process. And that comes from Article 1, Section 1, where it says all legislative power herein granted shall be vested in a Congress. All legislative powers, power to make law, modify law, strike down law, all legislative powers herein granted shall be vested in a Congress. So only Congress can begin that process of removing legislation. It doesn't automatically get removed just because a president had signed them, those pieces of legislation, and then it turns out he was guilty of treason, or it turns out he wasn't eligible. They stay on the books. It's up to the legislature. It's up to our Congress to begin the process of removing them if they so desire. All right, that all said, thank you for watching. Appreciate all of you guys that are out there watching, guys and gals. If you have not subscribed to this page, right down below, see that down there? Or actually, it's over here. Over here. Yeah, there we go. Anyway, subscribe button, hit it. And right next to that subscribe button, you'll see this little bell. If you want to get notifications that I put out a new video, hit that bell also after you subscribe. If you want to donate to help the cause, DouglasVGibbs.com or politicalpistachio.com. Find the donate button. I'm actually right now redoing DouglasVGibbs.com main page, so it's easier to find my pages, so it's more easier to navigate. And if you want, and let me show you this real quick. I have a new bumper sticker I wanted to show you. The U.S. Constitution trumps socialism. Send me $5 and your address when you donate, and I'll send you a bumper sticker. When you donate, on the little screen when it comes up, it'll ask if you want your address shared with me. Do so, and then shoot me an email that you did so, and that you did it because you want a bumper sticker, and I'll mail you a bumper sticker. $5. I got to cover my costs. So, U.S. Constitution trumps socialism bumper sticker. I'll send you one. And that all said, have a great one. Stay safe, stay patriotic, and, well, stay constitutional. We'll see you next time.